Something fascinating just unfolded inside the walls of the Court of Appeal. If you think legal battles are just dry recitations of law books and paperwork, you haven't been paying attention to the trial of Mazi Nnamdi Kanu. Today, the atmosphere shifted. It wasn't just another routine adjournment or a typical legal back and forth. The appeal court panel turned its gaze directly toward Kanu's prominent defense attorney, Maxwell Okpara. They didn't just listen to his arguments, they questioned him, they pressed him, and in doing so, they exposed the raw, high-stakes friction between political ideology and hard, unyielding legal reality. For years, the legal defense of the IPOB leader has been treated like a high-stakes chess match, played out across the Federal High Court, the Court of Appeal, and all the way to the Supreme Court. Every move is heavily scrutinized by millions across Nigeria and the diaspora. But what happens when the judges themselves begin to openly question the very strategy of the defense? What happens when a legal team, known for its fierce public rhetoric, faces the cold, clinical reality of a three-member judicial panel demanding immediate answers? Today, we are stripping away the political noise. We are diving straight into the courtroom drama to analyze exactly what the judges asked, how Maxwell Okpara responded, and why this specific interaction could signal a dramatic shift in how the state handles the most sensitive legal case in modern Nigerian history. Stick around, because the details of this courtroom exchange reveal a lot more than what you're seeing in the mainstream headlines. To truly understand why today's questioning by the appeal court is such a critical milestone, we have to look at the landscape leading up to this moment. The legal battles surrounding Nnamdi Kanu have never been simple. They are a massive web of terrorism charges, treasonable felony allegations, human rights enforcement suits, and jurisdictional disputes. Over the years, Kanu's defense line has seen dramatic shifts in personnel and internal dynamics. We've seen heavyweights like Professor Mike Ozcombe, senior advocate of Nigeria, and Barrister Ifeanyi Ejiofor lead complex appeal processes. Later, we saw the prominent emergence of Aloy Ejimaka alongside Maxwell Okpara. This internal evolution of the legal team hasn't just changed the faces at the defense table, it has fundamentally altered the courtroom strategy. Historically, Kanu's defense has operated on two parallel tracks. First is the substantive criminal case, which means fighting the state's severe charges of terrorism. Second is the fundamental rights enforcement track, which involves suing the Department of State Services and the Attorney General of the Federation over his treatment in custody, his access to specialized medical care, and his freedom of religion. But here is where the legal gears usually grind to a halt. The state has consistently countered these moves by altering the underlying facts. For instance, when the defense sues over conditions inside a DSS facility, the state responds by shifting the legal status of the detainee, moving the trial forward, or relocating the defendant entirely, such as to correctional facilities. When the underlying reality changes, appellate courts routinely look at the defense team and ask a devastating question: has your case become purely academic? This is the exact legal corner that Maxwell Okpara found himself navigating today. When a three-member panel of appellate justices looks down from the bench and begins probing your applications, they aren't looking for political speeches or emotional appeals. They want to know one thing: does your application still hold water under the strict letters of the law, or has the clock simply run out on your strategy? Let's recreate the scene inside the courtroom today. Imagine the silence that falls over a crowded room when the presiding justice leans forward toward the microphone. The panel's line of questioning for Maxwell Okpara didn't just touch upon the surface of the filings, it cut straight to the core of the defense's operational approach. The first major line of inquiry centered on procedural utility. The justices pointedly asked the defense to clarify the exact relief they were seeking from the court at this stage of the proceedings. The core judicial question put to Okpara was this: if the circumstances of the primary detention have fundamentally evolved, if judgments have been delivered at the lower courts and physical custody has been reassigned, what tangible, enforceable order can this appellate court possibly issue that hasn't already been overtaken by real-world events? Think about the weight of that question. In Nigerian jurisprudence, an appellate court prides itself on efficiency. They do not sit to deliberate on theoretical scenarios or issue declarations that carry no practical weight. They deal in enforceable mandates. When pressed on this, Okpara had to walk a razor-thin legal tightrope. On one hand, as a defense counsel, you cannot simply concede that your hard-fought appeal is obsolete. You must argue that the foundational violations committed by the state leave a permanent legal stain that the court must address, regardless of how the landscape has changed. On the other hand, you are addressing a panel of highly experienced justices who are bound by judicial notice, meaning they are legally required to recognize the current, updated status of the criminal trials and custody arrangements below them. The second wave of questioning from the bench targeted the nature of the evidence brought forward to substantiate allegations of rights violations. The panel pushed the defense on whether their claims were backed by independent, verifiable expert metrics, or if they relied heavily on the subjective assertions of the client. This is a recurring hurdle for Kanu's legal representation. In complex constitutional matters, the burden of proof rests squarely on the shoulders of the applicant. When alleging complex issues, such as the systematic denial of specialized medical care or a lack of qualified medical personnel within state facilities, the court expects a mountain of concrete, unassailable documentation. When the panel openly questions the sufficiency of that proof, it sends a chilling signal through the entire defense apparatus. It forces an immediate, real-time recalculation of the case's viability. So what does this intense interaction tell us about the broader trajectory of the Nnamdi Kanu case? It exposes a structural vulnerability that has plagued this legal saga for a long time: the delicate coordination of the legal team. As we've seen documented across various legal circles and internal reviews, including insights from chambers closely tied to the history of this case, the defense has occasionally suffered from a lack of unified harmony. When multiple lawyers are addressing the court simultaneously, or when updated bail applications are built upon older frameworks without introducing fresh, dynamic facts, the state's prosecutors capitalize on the confusion instantly. When the appeal court systematically questions a seasoned lawyer like Maxwell Okpara, they are essentially signaling that the era of relying on public sentiment to carry a courtroom argument is entirely over. The bench is demanding absolute precision. They are indicating that if the defense wants to secure a landmark victory that stands the test of time, they must present ironclad, updated arguments that cannot be easily bypassed by the state's administrative maneuvers. Today's courtroom exchange wasn't just a minor blip in a long-running trial. It was a stark reminder of how the wheels of justice turn in Nigeria's highest legal institutions. Maxwell Okpara's experience before the panel today highlights a crucial truth. In the theater of constitutional law, passion must be meticulously matched by procedural perfection. As the legal teams head back to their chambers to draft their next responses, one thing is absolutely certain: the state is watching, the public is waiting, and the appellate justices are holding both sides to an unforgiving standard. The strategy used yesterday will not win the battles of tomorrow. What do you think about how the appeal court handled the defense team today? Was the panel's intense questioning a necessary push for legal clarity, or is the defense facing an uphill battle against a system determined to run down the clock? Drop your thoughts in the comments section below. Let's get a respectful, analytical conversation going. Don't forget to hit that like button, subscribe to the channel, and turn on notifications so you never miss a deep dive into the legal and political events shaping our world today. Until next time, stay informed.